So it's really about your present state at the time, and if you're able to understand the proceedings in the court.
The defendant does not seek to seal the entire case record, but only the competency motion proposed entry that disclose or concern defendant's mental health condition and competency evaluation.
15 children removed from an Ohio home may come from their father, who's expected to make a request that could turn the entire case upside down. I'll tell you all about it. I'm Anjanette Levy, and this is Crime Fix.
A man stands accused of creating a private world of unspeakable neglect for 16 children, and his first public demand is for a locked door. Not a denial of the facts, not a proclamation of innocence, a request to hide the request. Think of a house where every single window has been painted black from the inside. For years, nobody saw in. The state alleges the conditions inside that house rewired the biological development of over a dozen minors. Now, the legal process demands those windows be pried open, and the defense has responded by asking the court to install a blindfold on the mechanism of justice itself. Before we go deeper into what the documents actually show, make sure you're subscribed to Endless Crime, because we don't just cover the story, we follow the evidence.
Gary Cers Junior has been in jail in Southeast Ohio since June 30th. He's the father of the 16 children that sheriff's deputies and state agents removed from the house in Vinton County. Cers' attorney is making a move that could bring his case to a screeching halt. You'll recall the conditions in the home were described as disgusting. The children ranging in age from 1.5 to 18. All of them were largely off the radar for years, with the exception of a truancy complaint filed in neighboring Gallia County back in 2021. Gary Cers Jr. faces 16 counts of child endangering. His wife, Elizabeth Cers, faces the same charges. Gary Jr.'s parents, Gary Cers Sr. and Christina Cers, face the same charges. All four have pleaded not guilty. Now, the child endangering charge states that the children were abused and that the abuse resulted in serious physical harm. All of the children are in therapy.
The filing lands with the clinical precision of a scalpel. Attorney Arley Roberts, representing Gary Cers Jr., has submitted a motion in the Vinton County Court of Common Pleas seeking leave to file a competency evaluation request entirely under seal.
Motion requesting a competency evaluation under seal. That means we wouldn't be able to read it. Defendant's competency to stand trial has been raised, and the documents at issue concern defendant's present mental health condition and requests for psychiatric examination. These documents contain highly sensitive mental health information or information directly reflecting defendant's psychiatric condition, the public disclosure of which would unnecessarily invade defendant's privacy and compromise the confidentiality of competency-related proceedings. Defendant seeks only limited sealing. Defendant does not seek to seal the entire case record, but only the competency motion, proposed entry that disclose or concern defendant's mental health condition, and competency evaluation. No less restrictive alternative would adequately protect the confidentiality interests at issue, because the substance of the filing itself concerns defendant's mental condition and need for evaluation. Good cause, therefore, exists to permit the filing of these limited documents under seal. So in that motion asking for leave to seal the motion, Attorney Roberts makes it clear that he has highly sensitive mental health information related to his client's current mental condition. And he's making it clear that he wants him to undergo a...
The justification is dense. It speaks of protecting highly sensitive mental health information, preventing the unnecessary invasion of the defendant's privacy, and avoiding the compromise of confidentiality and competency-related proceedings. It argues that no less restrictive alternative would adequately protect the interests at issue. The language is polite, legally flawless, and impenetrable, but strip away the procedural politeness, and the raw architecture of the strategy becomes visible. The defense is asking the public to leave the room before the trial even begins. The irony detonates in the gap between the crime and the request. The state's complaint, laid out in charging documents, alleges an environment of radical transparency in the worst sense. Excrement, decay, physical harm, a universe of suffering where nothing was hidden from the children, but everything was hidden from the outside. The system failed to detect them because they were functionally invisible. Now the father's legal strategy pivots, not on a robust defense mounted in the sunlight of public scrutiny, but on a plea to operate inside a vault. This is the request to hide the request. The prosecution's theory, detailed in the initial complaints, is not that Gary Cers Jr. made a mistake. It is that he committed 16 separate acts of felony child endangerment resulting in serious physical harm. The affidavit outlines a reality where children were found unable to communicate in basic sentences, their development stolen by years of isolation. You cannot comprehend the audacity of a sealed motion without understanding the magnitude of the exposure. The family unit lived entirely off the grid, bearing one truancy complaint across the county line in Gallia County in 2021. That single complaint was a thread that was never pulled hard enough. Now consider the timeline. The sheriff's office executed the removal on June 30th. In the weeks following, Gary Jr. appeared in court, stood in front of the judge, and demonstrated a rational, self-protective instinct. When asked how he pleaded, he did not ramble. He did not fail to recognize the judge. He turned and asked to speak with a lawyer. He articulated his right to counsel. This was captured on the public record. Yet, according to the new motion, the very mind that knew to pause the proceedings and request an attorney is now allegedly so fragile that even the request for an evaluation of that mind must be hidden from the public eye. The dissonance is staggering. The forensic psychiatrist evaluating this case would call this a distinction between present state and retrospective sanity. The law does not care if Gary Cers Jr. was mentally ill during the years the state says he and his co-defendants were hiding the children. Competency is a narrow surgical question. It asks whether, right now, as you sit in jail, you understand the roles of the prosecutor, the defense attorney, and the judge. It asks if you can assist in your own defense. The father of 16 children, the man who prosecutors say orchestrated a closed system that lasted nearly 2 decades, is now, according to his lawyer, struggling to grasp the mechanics of a courtroom.
Answer that question for us. He's a forensic psychiatrist and performs competency evaluations. Thanks for joining us, Dr. Bober.
Great to be here.
Talk to me, if you would, a little bit about, first of all, this request. The attorney for Gary Cers Jr. is raising competency as an issue. Does that surprise you?
No, it doesn't. In the state of Ohio, people are presumed to be competent, and competency can be raised by either the prosecution, the defense, or the judge themselves. So in this particular case, what we're looking at is the defendant's present state of mind. Distinguish that from their state of mind during the commission of the crime, which would be a sanity evaluation. And so we're looking at a two-pronged test. We're looking at if the defendant is able to understand the nature and the objectives of the proceedings against them, and they're able to assist in their own defense. So if they are deficient in either one of those or both, they would be found incompetent.
Mm-hmm. The judge will more than likely grant this motion, this request from Gary Cers Jr.'s attorney to file this motion under seal because it contains, in his view, mental health information. So we're at a loss here for knowing a lot more about this family, but it's astounding to me that he would have any concrete mental health information available just in the way they were living. And we don't really know if he was receiving any mental health treatment over the last, 5 years or so.
All true. And it's important to note that even if you are suffering from a psychiatric illness, for example, schizophrenia or bipolar disorder, that doesn't per se mean that you will be found incompetent. So it's really about your present state at the time, and if you're able to understand the proceedings in the court and work with your attorney. Some of the skills that we're talking about, for example, would be knowing the roles of the various courtroom participants, knowing the role of the prosecutor and the defense attorney. So, for example, a question we may ask is, can the defense attorney and the prosecutor ever switch places? We're trying to make sure that the defendant and their constitutional rights are protected and they're able to participate in the process and do so in a way that's effective for them.
Earlier we showed a clip of Gary Jr. in court. The attorney, or the judge rather, during the initial appearance was explaining to him the pleas he could enter, and he asked to talk to a lawyer before doing so. And then the judge, of course, understood that and entered a not guilty plea on his behalf. So that right there shows me that he understood enough to actually ask for a lawyer. He wanted to consult with an attorney. What does that tell you about his potential competence here?
I don't know if we could draw too many conclusions from that. I mean, he may have known enough to know that he knows what he doesn't know and he needs to ask an attorney. If he were to be found incompetent, then the court looks at, is he incompetent but restorable or not restorable? If he's incompetent but potentially restorable, he would be committed to a psychiatric hospital or some outpatient facility where they could try to restore his competency and potentially receive involuntary medication. And generally, with serious felonies in the state of Ohio, that could be up to a year. If he's incompetent but not restorable, then at some point he may be committed civilly to a psychiatric hospital if the court believes that he's guilty of the crime by clear and convincing evidence and he's still a danger to the community. He could be committed to a psychiatric hospital up till what the maximum sentence would be if he were to be found guilty of the crime.
Mm-hmm. If Gary Cers Junior comes into your office or in the alternative, you go to a jail to evaluate Gary Cers Junior for competency. How does that evaluation take place? How do you assess competency?
So it can be done by a clinical interview, and there are also a number of different instruments that can be used as well. But basically, we go down the list and we're looking for these skills that they would need in the courtroom, in addition to assisting in their own defense, working with their attorney. For example, if someone is in the courtroom and they suffer from a mental illness or a defect where they can't sit still and they can't maintain composure and work with their attorney, then they're not going to be able to assist in their own defense. So there's all sorts of things that we look for in these types of evaluations.
Mm-hmm. How long does that take, that evaluation? Is that something that can be done, in an afternoon? Does it take a couple of meetings with a defendant?
Usually it takes a few hours. It can be done within 2 or 3 visits, and sometimes it can be done within a visit, depending on the severity of their illness. If their illness is so severe that it's immediately obvious that this person is not going to be able to work within that time frame, then you know pretty quickly what you're dealing with.
Do defendants ever feign incompetency during an evaluation or fake it or try to exacerbate symptoms?
Yes, and very often psychologists will use instruments to detect that malingering or feigning that you're describing, which is not uncommon and for obvious reasons why they wouldn't want to be found competent to appear in court.
So do you think that this will be something that can be done rather quickly, this evaluation?
I think so. I think we could probably get away with this in an afternoon.
Do you think that this will be raised for the other defendants? And I'm asking you to speculate a little bit here, but we already have Gary Cers Senior undergoing a competency evaluation. And I think we could all see during his arraignment that he's clearly seemed a little out of it and didn't understand what was going on fully. So I think that's a much different situation. We have an elderly man dealing with a serious medical condition, and we don't know what that is. But this is different. This is a man in his mid-30s who has fathered, as far as we know, 16 children, and he is accused of abusing them and causing, serious physical harm to these children. That's the charge.
Well, it's true. And there's a lot of layers to this, right? So if you're someone who's in the public who's looking at this case, you're looking at the way this guy treated these kids and you're thinking, this guy has to be mentally ill if he would treat these kids this way and he would do it for so long. But again, that doesn't necessarily mean he's incompetent. That is a totally separate skill set from, again, being found not guilty by reason of insanity. Two completely separate things. One is looking at his presence of mind during the time that he was committing the crime, and the other is looking at his present state of mind right now.
Yeah, and whether he can really assist his attorney with his defense.
I also think it's interesting that the attorney wanted to seal the information in the docket, which may have to do with the fact that he was receiving some kind of psychiatric treatment, although it would be hard to imagine in these conditions that he was. Perhaps there is information that the attorney wants to protect to keep his information private.
Yeah, I found it interesting that he was forecasting and telling us what his concerns are in the motion to seal and telling the court that. And then now, though, he's like, we need to keep the information sealed rather than redacting it. So it'll be interesting to see where this goes. Dr. Daniel Bober, thank you so much.
Thanks, Anjanette.
Stop and process the national consequence of that juxtaposition. A system that allegedly evaded social services, school truancy officers, and home visits requires a sophisticated, organized, and sustained ability to plan. If that ability existed to commit the acts, what exactly has shattered it now? Is this a medical reality, or is this the first move in a long game to delay the judgment of the children who are finally learning to write their own names in therapeutic foster care? Here is the ticking clock. If the mind of the accused can be sealed off for a year of restoration treatment, do the memories of the victims become just as easy to bury? This isn't just a legal procedure. It's a race against the healing of 16 witnesses. The request to hide the request surfaces again when we examine the parallel criminal docket. While facing these 16 felony counts, Gary Cers Junior is also battling 4 misdemeanor counts of public indecency.
Psychiatric evaluation. Gary Jr. also faces 4 misdemeanor counts of public indecency. He's accused of exposing himself to someone on 4 occasions between May 23rd and May 31st at the home on Omer Street. The complaint says the person Junior exposed himself to was not a family member. Now, this may be part of the reason, this competency issue.
These charges stem from incidents dated between May 23rd and May 31st, just weeks before the house was raided. The complaints allege that Junior exposed himself to a person who was not a family member on the very property on Omar Street. This is critical. The indecency charges place him in an active state of compulsion and outward, facing behavior immediately prior to his arrest. In that case, his attorney also requested a continuance, citing precisely this competency issue. We are being asked to believe that a man allegedly capable of calculated exposure is simultaneously incapable of understanding a plea offer. This is not a conversation about mental health stigma. This is a conversation about public access. The motion requests limited sealing. It clarifies the defense does not wish to seal the entire case record, just the part that reveals the defendant's psychiatric condition and the evaluation request. But it is precisely this part that the public has a compelling interest in reviewing. In Ohio, the presumption of openness in court proceedings is a constitutional bedrock. It yields only when an accused's right to a fair trial is clearly and substantially threatened. Yet here, the threat is defined vaguely as confidentiality interests. The argument is that the very substance of the filing concerns a mental condition, and therefore good because exists to hide it. It is a tautology that eats itself. And so we arrive at the moral refrain that cuts through the legal hedging the request to hide the request. It dams the process to an echo chamber. It leaves 16 children in foster care, their identities protected by law, while the man who presided over their alleged physical dismantling seeks protection of his own psyche. The family tree reinforces the absurdity. Gary Sr., the patriarch, is out on bond, undergoing treatment for a serious medical condition and already subject to a competency exam because he genuinely seemed lost in his first appearance. That is a 73-year-old man with visible physical decline. But Gary Jr. is 36. He moves without difficulty in the booking videos released by the Southeast Ohio Regional Jail. He follows commands, he walks, he sits, he listens. The sealed motion implies a hidden fragility entirely incongruent with the booking footage in the public domain. We are left with the unbearable silence of contradiction. Documentary evidence is the only light we have. The motion to seal is a public court filing arguing for its own disappearance. You can view it online in the Vinton County docket. We should read it not as a medical diagnosis, but as a tactical map. It signals a defense team trying to remove the emotional volatility of this case from the trial phase before it even arrives. When an indictment eventually comes down from the grand jury, the terrain will have already been sculpted by a sealed psychiatric narrative. What remains unanswered is the chasm between the hidden truth and the visible horror. If the evaluation request is sealed, and the evaluation results are sealed, and the restoration hearings are sealed, the public will receive only a binary output at the end, competent or not. The machinery of justice will grind in darkness. This is precisely how the house on Omar Street operated for years, silently, invisibly punishing children in a void.
I love having you join me. Jonna, tell me if you would, are you surprised by this request that Gary Cers Jr.'s attorney plans to make to the court for a competency evaluation?
Okay, so in all honesty, I'm not surprised because when you examine the facts of this case, this is like no other case I think we've analyzed in my career. Like, this is a really strange case with the level of neglect that went on with so many children for so long. Now, here's the one thing that I think our viewers have to keep in mind. A competency hearing or a competency determination is not the same as insanity. And a lot of people will confuse the two. So competency, why it makes sense here is because it's to gauge whether or not at the current time, so it doesn't look back really to the history, at the current time, does the defendant understand the proceedings and can he assist in his own defense? So we can probably make a short leap between, well, all right, there was a lot going on here for a long time that probably that indicates this defendant had deficient mental capacities. And now here we are facing several charges, several felony charges. And does he get it? Does he know where he is? Does he know what a court proceeding is? Does he understand what he is charged with? Does he understand what he's done? And so it does make sense. And I am not surprised by the current motion on his behalf.
Uh, it doesn't surprise me either. But as you mentioned, and I think you made a very good point, competency is a totally different issue from, an insanity defense.
Mhm.
So basically, his attorney is saying, like, I've met with him. I have concerns that he doesn't understand what's going on.
Mhm.
And so now a mental health expert is going to evaluate that and present a report to the court. How common do you think these competency exams are in criminal cases? Because I know throughout the years, as I've covered cases in court, competency has been raised in a number of cases.
Yeah, they are fairly done frequently, I would say, depending on the nature of the case. And like I said, there could be a complete disconnect between what is going on inside the mind of a defendant now versus what was going on at the time crimes were committed. And you have to keep in mind, in this case, the crimes they must have begun years ago. We've got 16 kids ranging from infant to 8 months to 18 years. That's a long time to live in that kind of squalor. And here's the one thing I will tell you that bugged me. I said to myself, well, he must be competent because this family knew how to evade detection. They knew how to hide. They weren't in school. How were they living? Nobody applied for social services. Do you do that on purpose so that you can live like wild animals? I'm sorry to say it, but that's kind of how they were living. The reports are when the police finally got to this family, a lot of the children couldn't speak, they couldn't write their name. I mean, this is just years and years of not being raised as we all socially are normally, and it's really, really sad. So in this case, there has to be something going on. So the competency issue is one thing, and if he is found incompetent, that doesn't mean it's game over. That
Right.
means they'll work on him to get him competent, and then the case can come back.
Well, it's his father, Gary Sr., they've raised that issue with his father because he seemed really out of it at his initial court appearance. So I'm wondering, are we going to see this raised in the other cases? Because, Jonna, we're really at the complaint phase of this case where they've waived their preliminary hearings. We
Mhm.
haven't even seen an indictment yet. We don't know what charges that will be indicted at grand jury and presented and requested at grand jury. We know it will likely be child endangering, but how many more? And
Mhm.
who gets indicted for what? That's still an outstanding question.
Big question. And I will say something that I find really interesting about this. Again, nothing about this case warms my heart. Do not get me wrong. But here's when I look at it and I say, okay, this is horrible. The conditions are I haven't seen anything like this. But the one little tiny saving grace for the adults in the room is that they all seem to be living that way, as
Mhm.
opposed to cases where you have parents that are eating filet mignon, and the kids are the ones who are being malnourished and are not getting the care that they need. This whole family was living just like they were cave people, and worse. So to me, that might be something that I would hang my hat on if I had to defend any of these family members.
Yeah, it's astounding. It's stunning, and we're still waiting for more answers because at this point, we certainly have more questions than we do answers. I mean, the only update we have on the children is that they're in therapeutic foster care. We don't even know their exact conditions, and maybe we shouldn't know that as the public because it's health information. It's protected by HIPAA, but it would be nice to receive some sort of update on how the children are doing. And I'm sure you can agree with that as well.
It's going to be such a long road for these kids, and probably even worse for the older ones. I think the oldest is 18 years old. And if that child lived, since we have no records, like so if that child lived his or her entire life without reading, writing, arithmetic, without proper nourishment, with bacteria, with feces, with disgust, with not being socialized, that's hard. At least the younger ones, I think, have a little bit of a fighting chance if they get into really good foster care. And there are some really good foster parents out there. So fingers crossed for that.
Here is your call to research. Go to the Vinton County Court of Common Pleas public access portal and locate case number CR2D418. Read the text of the motion for leave to file under seal. Look at the language justifying the closure. Then ask yourself this one question in the comments. If the facts of the house were hidden for a decade, and the facts of the mind are now being hidden by the court, at what point does transparency cease to be a principle and become a weapon against the forgotten victims? The evidence is a chain. Each link is a sealed motion or a child who couldn't speak. Endless Cryme is here to ensure the links do not become a noose around public accountability. If you believe the public record belongs to the public, hit like, share this script, subscribe, and turn on notifications so you never miss a filing. Justice does not happen silently. It happens right here, one document at a time.